All right. Good evening, everyone. It's good to see everyone in person again. We'll call the meeting to order. I will just remind everyone in the meeting that it's being streamed live on YouTube for those that are not in attendance today. And I will declare that we have a quorum so we can proceed with the both public comments hearing as well as ultimately the business meeting that will follow. We have some new commissioners that have joined us, and typically we would give it a bit of an introduction and join, but given that it coincides with our public comments and our hearing, we always go around the room and have everyone introduce themselves. So not to be duplicative in the efforts, we will go ahead and do that. So I'll start with you and then we'll work our way.
Sure. Good evening. I'm Lisa Spitfall, a public member of the committee. I'm Shannon Avery. I'm a judge in the circuit court for Baltimore City, and I am chair of the guidelines subcommittee.
I'm Carrie Williams. I'm principal counsel for criminal policy with the Maryland Office of the Attorney General, and I'm here on behalf of Attorney General Fosh.
I'm Chris West. I'm a state senator from District 42, which runs from Towson through northern Baltimore County and starting on January 1st, westward into Carroll County.
I'm Melanie Shaw. I'm a judge on the Court of Special Appeals, to be known soon as the Appellate Court of Maryland. Have to remember that.
I'm Michelle Saunders. I'm a judge sitting in the District Court for Calvert County.
Hi, I'm Olivia Miller, and I am a forensic interviewer and a victim advocate, filling the victim advocate role from Harford County.
Hi, everyone. I'm Brian Johnson. I'm a professor of criminology and criminal justice at the University of Maryland.
Good evening, everyone. I'm Richard Fincy. I am the defense bar representative on the commission and a member of the Sentencing Guidelines Subcommittee.
And good evening. I'm Don Zaremba. I am the general counsel for the Office of Public Defender. I on behalf of the public defender, Natasha Garti.
Kyle Shearer. I'm a public member and I'm a partner at Venable.
I'm Robert Green, Secretary of the Department of Public Safety and Correctional Services. Good evening.
Good evening. I'm Sandy Bartlett, and I am a member of the House of Delegates. I represent District 32 in Anne Arundel County. Good evening.
I'm Sarah Bowles, staff, program analyst for the commission.
Good evening. I'm Stacy Najak, and I'm the research director for the commission.
Good evening. I'm Catherine Pembroke, the administrative and training coordinator for the commission.
Hi, I'm David Sule. I am the executive director for the Sentencing Commission.
I'm Brian DiLeonardo. I'm a judge for the Circuit Court of Carroll County and have the privilege of serving as chair on the committee. So with that, again, welcome and welcome to our new members, whatever court it happens to be now. But Judge Shaw, Judge Saunders, and Ms. Williams from the Attorney General's office, thank you all for joining.
Judge DiLeonardo, we also have two members of the commission. I'd like to judge who are participating virtually, and maybe so we can do it.
I certainly don't want to forget our members.
Starting with Mr. Harvey. Mr. Harvey, can you hear us? Would you be able to introduce yourself?
Hi, I'm Bob Harvey. I'm the state's attorney in Calvert County.
Great. And then I don't see her, but Ms. Grenier, are you available?
I have, for some reason, my camera's not working correctly, but Melinda Grenier, Assistant Director, Community Services, Frederick County Sheriff's Office. I represent corrections.
Great, thank you so much.
Thank you both. Sorry that I missed you, and just in time. We'll give him a moment to sit down, Senator Sidnor. We just went around to introduce, if you wouldn't mind introducing yourself.
Good evening, everyone. Charles Sidnor, Senator from District 44 in currently Baltimore City and Baltimore County.
Great, thank you, Senator. All right, so with the introduction again, thank you. It's wonderful to see everyone. We are here for public comments. Initially for that, Dr. Sule is going to give a presentation for the public on both the history of the Maryland Sentencing Commission, as well as a little bit of the background on what we do. So Dr. Sule.
Thank you, I appreciate that. Let me just see if I can, there we go. give me a second. Let's see if we can. Believe it or not, we did test this in advance. Okay, there we go. Thank you. All right. Well, good evening and welcome to the Maryland State Commission on Criminal Sentencing Policy 2022 public comments hearing. I just wanted to start by saying that the commission holds an annual public comments hearing as an opportunity to solicit feedback about the sentencing guidelines and the work of the Sentencing Commission. So to start, as Judge DeLeonardo alluded to, we thought it'd be a good idea to begin by offering some background information about the Sentencing Commission and about the history and the purpose of the guidelines. Maryland was one of the first states to initiate a sentencing guideline system. The judiciary introduced the concept of judicial sentencing guidelines in Maryland in the late 1970s in response to growing concerns regarding unwarranted sentencing disparity and in a general interest in sentencing by the public and the legislatures and other elected officials. So in 1979, in April of 1979, the Sentencing Guidelines Advisory Board was formed by the judiciary, and that board approved a system of voluntary guidelines to be piloted first in 4 jurisdictions. The sentencing guidelines were then approved for statewide use in the circuit courts in 1983. The guidelines in Maryland were in effect statewide for 15 years with oversight by the judiciary. And then in 1999, the legislature created a permanent independent sentencing commission to have oversight over the sentencing guidelines. And that is how the Maryland State Commission on Criminal Sentencing Policy was formed.
David, is it possible to make the live stream possible?
I cannot get rid of that box. Unfortunately, those in the YouTube view will not see that. I know it's not great for us here in the board, but yes, that is actually on the system's computer, not on my computer. So, and unfortunately, our IT person left. So, work on that for next meeting. As was introduced, and thank you for all our commissioners to introducing us, but the Sentencing Commission is an independent, objective agency. It is a balance of 19 members from all 3 branches of government. We went around and all introduced ourselves. As noted, is really kind of made up to be a group that is representative of the criminal justice system in its entirety and has a cross-section of criminal justice officials from all 3 branches of government, as well as 2 public members. Now, the enabling legislation that created the Sentencing Commission created a statement of intent that had 6 specific goals, and those are outlined as noted here in Criminal Procedure Article 6-202. And 6-202 states first that sentencing should be fair and proportional, and that sentencing policy should reduce unwarranted sentencing disparity, including any racial disparity. Second, sentencing policy should help citizens to understand how long a criminal will be confined. Third, sentencing policy should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, the sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And finally, sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. The Commission has a few primary responsibilities to help address these goals. The first responsibility is to implement and maintain the state's voluntary sentencing guidelines. And this is accomplished through the second major responsibility, which includes collection and maintenance of a database assembled via guidelines worksheets that are submitted through the Maryland Automated Guidelines System. The Commission uses guideline data to monitor circuit court sentencing practice. The Commission also examines sentencing patterns and reasons for departures for specific offense categories and within individual cell ranges to consider when changes to the guidelines are necessary. Finally, the Commission is responsible for providing training to criminal justice practitioners to promote the consistent application of the sentencing guidelines and accurate completion of the guidelines worksheet. So what are sentencing guidelines? Sentencing guidelines are a mechanism to encourage proportional, fair, and just sentences. The guidelines are a framework that systematically account for the common factor a judge considers in a typical case, and by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. This allows judges to consistently assign the same value or weight as their colleagues around the state for each of these factors. Accordingly, the guidelines promote consistent and equitable sentencing practices whereby offenders who are convicted of similar offenses with similar criminal histories are treated alike. So the easiest way to illustrate how the guidelines work is to just provide an example. And so the Maryland sentencing guidelines are scored on two primary factors: prior criminal record and the seriousness of the offense. And the sentencing guidelines in Maryland include 3 sentencing matrices for 3 broad categories of offenses: person offenses, drug offenses, and property offenses. I've illustrated here, which I know is a little difficult to see with that message in the middle, the property matrix. I did this one because it's smallest and easiest to put on the screen. The guidelines recommend whether to incarcerate an offender, and if so, provide a recommended sentencing range. The first column on the left side, which is a little difficult to see with the light, I see represents the offense seriousness category. 7 being the least serious offense, down to 2 being the most serious offense. The row going across the top is the offender score, and that is a summary scale ranging from 0 to 9, which measures an offender's criminal history. So if we consider an example, an offender with no prior record with an offender score of 0, who was convicted of theft less than $100, which is a category 7 offense, right? One of the lowest seriousness category offense. Then the guidelines range would in this case be at the intersection of offender score of 0 and seriousness category 7. And so the guidelines range here would be probation. So probation to probation, there is no upper range that differs in that particular category. The sentencing guidelines help to achieve proportionality as they represent and present incremental increases going from left to right, going across as the criminal history score increases from minor to more serious. And they also reflect offense severity and provide incremental increases as you move down the guidelines, going from the bottom going from the top of each grid to the bottom of each grid as the offense conviction ranges move from minor to more serious. So we refer to this as a 2-dimensional grid, right? That accounts for the offense seriousness and the prior criminal record, And that allows for the guidelines to account for the most common, but certainly not all characteristics that are relevant to the sentencing decision. Okay, there are a few basic principles regarding the Maryland sentencing guidelines. The first basic principle is that the guidelines in Maryland are voluntary. Judges may, at their discretion, depart from the guidelines. Second, the guidelines are also intended to be primarily descriptive. Guidelines that are primarily descriptive are not intended to tell judges how they should sentence. Rather, they are informed by data, and they are intended to illustrate to judges how their colleagues are sentencing on average for a typical case. Now, the descriptive nature of the guidelines means that they are not intended to be static. Rather, they are dynamic, and the guidelines may be amended when the data indicate that sentences are not consistent with sentencing guidelines ranges. And this is illustrated as we just recently adopted changes to the sentencing matrices for property and drug offenses effective July 1 of this year. Finally, Criminal Procedure Article 6-216 indicates that circuit court judges shall consider the guidelines at sentencing, but judges retain the option to sentence above or below the recommended guidelines range. Okay, I'm going to wrap up this kind of general background and history of the commission and just talk about a few of the planned activities that the Sentencing Commission has coming up. And this is just a selection of those, but these are some of the primary activities that we will be addressing in the near future. The first is the data dashboard. Last year during the legislative session, Senate Bill 763 passed, and it required the commission's annual report to add a new section that provides additional details about sentences for crimes of violence. And this bill, Senate Bill 763, also required the Sentencing Commission to create a data dashboard to make this information easily accessible from the Commission's website. The plan is to deploy the new data dashboard by January 31st, 2023 to correspond with the due date for the 2022 annual report. In addition to the data dashboard, the staff is also working to create a data extraction tool on the website that will assist in making the sentencing guidelines data even more easily accessible. And I'm going to speak a little bit more about both the dashboard and the data extraction tool during the executive director report during the business meeting. As discussed at prior meetings of the commission, during the 2023 budget review process, the Department of Legislative Services required the commission to create a report on racial biases at sentencing. We have discussed this at a few of our prior meetings, and the staff projects completion of this report by July 15th of 2023. We plan to further discuss this report at the commission's May 2023 meeting in advance of the July 15th date. And then finally, the staff is currently working with our programmers at the Department of Public Safety and Correctional Services to implement a new round of updates for the Maryland Automated Guideline System, or MAGS. Among a lengthy list of mostly minor updates, we are also planning for a more substantial change to revise how sentencing information is captured within MAGS. The staff developed a revised protocol that will simplify how sentence information is data entered into MAGS, and we believe the simplified process will be well received by the court users who provide this information in MAGS. So we are certainly looking forward to rolling out those updates. We're currently just getting started on that. We'll then have to go through extensive testing, et cetera, by staff, and then hopefully we'll be, deploying those changes within the next few months. So I'll wrap up there. I just wanted to note, since its inception, this commission has made it a goal to incorporate feedback from both the public and our criminal justice partners into our policy decisions. And the commission values this input and wishes to ensure that the sentencing guidelines remain a relevant and useful tool for practitioners and for the public. The annual public comments hearing that we have tonight is just one way in which the commission solicits and incorporates this feedback. And we encourage anyone that has questions or comments about the guidelines or the work of this commission to contact the commission, or any of you, our commissioners, at any point if you have questions, but certainly feel free to reach out to anyone on the staff to reach out to us at any time. And I've provided the website for the Sentencing Commission, which is MSCCSP.org, and also we're available via email or phone. And so I will end there, and I just want to thank everyone for the opportunity to provide that information.
So if I could just add on that point, having my time with the commission, both most recently in the position of chair, but prior to that being a member of the commission, it was really clear that a lot of the issues we tackle sometimes come from members of this commission. Sometimes they're coming from members of the public, either speaking to one of the members of this commission or contacting staff. And so I think as members, and I certainly have done that as well, it's incumbent to encourage our stakeholders that we represent at times to reach out if there are issues or concerns. So for example, just last week, someone was raising an issue about sentencing, and I said, well, we have public comment, or you can certainly put something in writing, and that we really do address those issues. We take a look at those issues. We've had issues that have been raised by people in the members of the public where there was extensive research, debate, and changes made to the guidelines as a result. So I just wanted to echo Dr. Slay's point, which is that is very true. This commission, even apart from others that I've been in, I have found to be incredibly receptive to public input and to involvement. And so I just thought it would be good, as we all represent different areas and different stakeholders, to not to forget to encourage that kind of discussion if they have issues or if there are concerns. So Before we get to the issue of speakers tonight, is there any other commissioner comments on the presentation? Okay, no? All right, well, Dr. Saleg, perhaps you can talk about the notice on the speakers and the speakers.
Right, absolutely. So I guess we'll just do one final call. I don't see anyone, but just make sure. I mean, this is a first for us, but I think we'll take it as a sign of what the great work that we're doing here. I choose to accept no other conclusion. But I think what we'll do is, we're seeing that there's no one else here, I think we can conclude the public comments portion of the hearing. So we can just take a real quick break, if that's okay with everyone. I am going to go ahead and start recording. So we are now back live. Thank you, everyone. So go ahead.
All right, very good. So again, I will declare that we have a quorum. Our first matter of business is the approval of minutes from September 15, 2022. Our previous meeting, you should have that included in your packet. So if there's a motion to approve, or a second? Second. Any discussion? No? All those in favor say aye. Aye. Anyone opposed? All right, the minutes are approved. So with that, we move to the guidelines subcommittee report. I'll refer to Shannon Avery.
All right, thank you so much. Okay, so the guidelines subcommittee, let me just say preliminarily, by way of description and introduction, that the guidelines subcommittee is the primary working group of the commission, and I've been chairing it for a number of years now, and we have a good balance of membership. Mr. Fincy, Senator Sidnor, Mr. Harvey. Am I leaving anyone out? No. Okay. So most of the questions that are presented to the commission come through the guidelines subcommittee first. We spend a lot of time taking apart these issues and questions and debating them. It's always a friendly debate and very collegial. It's a great group. And then what we do is we bring the issue, we vote, and if, whatever the vote is, we bring the issue to the commission. And frequently there's not a lot of controversy, and sometimes there is controversy, but in any event, the issues that we discuss and vote on are then presented to the commission that has its own independent vote. So we really are just kind of, we do a preliminary review, I would say, which is entitled to little or no deference whatsoever, but it is helpful in processing the issues and questions that come before the commission. So that being said, our last meeting was November 16th, and we did not have a quorum. We didn't have any issues that are presented to the commission tonight as action items, but I am going to let David Soule make a kind of a brief abbreviated presentation of these issues, so you have a sense of what we're talking about, because they are still on the horizon for the commission for action items in the future.
Thank you. I appreciate that. So at the subcommittee met on November 16, 2022, because two of the four members were unable to participate, there was a discussion, as Judge Avery noted. So the three issues and corresponding memorandum were placed on the agenda. Our anticipation is that we would receive feedback. Each of these three issues, if you had a chance to go through the memorandum, are somewhat complicated. And so we thought in this instance, it wouldn't be a bad idea to put feedback from the full commission to then bring back to the subcommittee to deliberate and then potentially bring forward action items at the next commission meeting, which would be planned for May 2023. So there are the four agenda items. I am asking, we're all going to take a little bit of turns tag team some of these issues as the staff members work through these. So I'm going to ask Sarah to go first to present agenda item 4A.
Sure. So I'll be presenting on the memo review of guidelines for cases involving mandatory consecutive sentences. This issue was first discussed by the subcommittee at its August 30th meeting. And at that time, the guidelines subcommittee had requested that the staff analyze the sentencing guidelines data pertaining to sentences for offenses involving mandatory consecutive sentences. And so the present memo you have now includes the results of those analyses beginning on page 4. Over the years, including most recently on July 12th of this year, Commission staff have received inquiries from practitioners about why the guidelines do not stack in situations where one sentence is mandated to run consecutive to another sentence. Give me 1 second. Thank you. Okay, so in response to these inquiries, Commission staff identified 10 offenses that require judges to run a sentence consecutive to another offense for which the offender is being sentenced. These offenses are listed in the memo in Appendix 1. As this issue is raised periodically by practitioners, Commission staff believe that the issue is worth considering by the subcommittee. In other sentencing scenarios involving multiple convictions, the guidelines employ a stacking rule. So for example, a stacking rule applies in a single sentencing event involving 2 or more seriousness category 1 or 2 offenses. In these scenarios, both the lower and upper guidelines limits for the seriousness category 1 or 2 offenses stack. Stacking also occurs when there is a criminal event with multiple victims and not more than 1 seriousness category 1 or 2 offense. This is also known as the multiple victim stacking. In these cases, only the upper limits of the guidelines range is stacked for those offenses involving different victims. Arguably, a stacking rule should also apply in scenarios where a statute requires an offense to run consecutive to another offense in the criminal event, to reflect the intent of the legislature that the sentences are to run consecutively. Now, there is data to support this proposed rule. Sentencing guidelines, as noted beginning on page 4 of the memo, reflect that overall above departures are more common in sentencing events involving offenses with mandatory consecutive sentences when compared with all sentencing events, and that the median value for the guidelines applicable sentence as a percentage of the guidelines midpoint is higher in sentencing events involving offenses with mandatory consecutive sentences. So from a policy standpoint, applying the stacking rule to mandatory consecutive sentences makes sense. As a practical matter, though, doing so is complicated by the fact that some statutes require mandatory consecutive sentences employ different language than others. So some offenses involve some type of enhancement and provide that the penalty or sentence should be consecutive to the sentence for the offense that forms the basis for the enhanced crime. In contrast, other sentencing provisions for crimes provide a more general and ambiguous statement regarding the mandatory consecutive nature of the sentence, stating that the sentence shall be consecutive to any other sentence imposed or to any other sentence imposed under any other provision of law. It is unclear whether such language would apply only to sentences within the same criminal event. In the interest of creating consistency, uniformity, and clarity in the application of the rule, Commission staff is proposing a stacking rule that would apply only to sentences within the same criminal event. Now, the question also arises whether both the lower and upper limits of the guidelines recommendations should stack, or whether just the upper limit should stack. Both approaches are worth considering, and so accordingly in the proposed revisions, staff provide 2 alternate revisions to the guideline, one of which stacks only the upper limits of the offenses, which would be similar to the multiple victim stacking rule, and one of which stacks both the lower and upper limits. With these considerations in mind, the Commission may wish to revise the Sentencing Guidelines Manual and COMAR to account for offenses with mandatory consecutive sentences. If the Commission wishes to explore this option, staff proposes the revisions contained in the present memo. The Commission may consider asking the Guidelines Subcommittee to review these proposed revisions and offer a recommendation on whether to adopt them. And that concludes my summary. I'll now turn it over to the Commission for further discussion. Sarah, can you walk us through the example? Yeah. To illustrate. In the memo?
Yes.
Yeah.
Dr. Soleil, would you like me to move a microphone down there
Sure.
a bit closer? I'm happy to do it.
I'll have that just in case.
I think I may have heard someone say they.
Oh, thank you. So I will go to the example that is provided with the recommended proposed revisions, which is on page 9. So I'm looking at example number 1. So in these proposed revisions, we would be proposing that only the upper limits of the guidelines stack. So similar to the multiple victim stacking. The offense we provide as an example here is committing a crime of violence in the presence of a child. That is one offense in which the statute provides that it shall be run consecutively to, I believe it is the act establishing the violation of the section. So the commit a crime of violence in the presence of a child should run consecutively to the crime of violence, the underlying crime of violence. So in this scenario, the defendant was convicted of robbery, assault second degree, and the commit a crime of violence in the presence of a child. Now, in just a regular guideline scenario, you would take the highest of the lower and the highest of the highest to get the overall guidelines range, which in this case would be 3 to 7 years. But if we're going to stack the upper ranges for both the underlying offense and the commit a crime of violence in the presence of a minor, you would end up with 3 to 12 years, and that's the 5-7 years combined together. And that would be to reflect what's expressed in the statute, and that it should run consecutive to the underlying offense. And then we provide a very similar example, actually the same example for the next section, except you would be stacking both the lower and the upper limits, and that's similar to what we do for seriousness category 1 and 2 offenses, and those are the most serious offenses. So if you have 2 murders, 2 second-degree murders, you're stacking both the lower and the upper guidelines ranges. And so in this proposed revision, you would be applying the same theory and stacking both the lower and the upper ranges, and you would end up with a range of 5 to 12 years. And that's how it would differ from, just a normal guideline scenario where the range would be 3 years to 7 years.
Thank you, Sarah. So I think one of the main points that we brought up was that given the way the guidelines rules work, if it is 2 convictions within the same criminal offense, it's just one offense that's controlling the guidelines. So the way they're currently set up, if you are convicted of this additional conviction, which requires a consecutive sentence, for instance, committing the crime of violence in the presence of a minor, the guidelines would be equal to just whatever they are for the underlying crime of violence. Let's say it's a robbery or a first-degree assault. They're not being increased at all to reflect the additional component, which is this conviction for committing the crime in front of a minor. So the guidelines essentially aren't accounting for that. And so what the reason this came up, this was brought forward to us on a few occasions, should the guidelines account for this seemingly more serious scenario? And so what the staff proposed was, if the commission does think that the guidelines should, consider that, then you could address it in one of 2 ways. It would be to kind of treat it, you would stack both the lower and upper for both offenses, or you could just stack the upper limits like we do for the multiple victim stacking rule. And there was some discussion about both of these, not necessarily an agreement on the subcommittee, kind of the pros and cons of those 2 approaches.
I think one of the considerations is how do we best reflect what is the actual practice when you have those offenses, and it's hard. It's hard to have the staff go and make these research inquiries, but that's part of what we do. That's part of the conversation is. Again, kind of focusing on the descriptive nature of the guidelines. We're trying to create guidelines so that judges can see what other judges across regional and demographic differences are doing under similar circumstances. There are other considerations depending on where we come from. I generally am coming from the perspective of a sentencing judge, and also I try to stay as true as possible to the policy statement contained in our enabling statute. Anyone else on the guideline subcommittee want to weigh in?
Sure.
Yeah.
I think that's an accurate reflection of what we spoke about at the guideline subcommittee meeting. I would also note for members of the commission that may not be aware that none of these statutes require additional sentences. They're not mandatory sentences that are required. They require consecutive sentences. They could be consecutive suspended sentences. It's, from my recollection of many of these statutes being passed, it's more intended to make sure that a judge recognizes this additional offense and assigns some of the punishment to that offense, whether it be additional time or additional suspended time on the sentencing event. So that's another complicating factor in trying to assess how it's handled or how it should be handled, because judges do it differently. And we're supposed to be descriptive, right?
Yeah, but there's gray area too, because it's very, there's some offenses that are very rare that they get charged, prosecuted, convicted. And so we don't have data to inform our decision making. So we kind of then venture into what should the outcome be. And so, we try to focus more on what the outcomes are and be descriptive, but sometimes we're in a gray area. So
to that point, these are rare offenses, and the convictions for these are rare. There is data. There is data that we present here. We were able to do some descriptive analysis, but there's not a lot of data. So the sample sizes, the N's as we refer to, are very small for the most part, except for maybe fentanyl offense and distributing CS near school and the committing of crime violence and violence. Even those N's are over, what do we look at here, a 5-year period. We're still talking, 10 a year on average, right? So they are a small number. There is some evidence, though, if you look at the descriptive nature of it, that judges are treating these cases as more serious cases. They are more likely to depart above the guidelines than cases that do not involve these consecutive sentences. So there is some minimal. So when we always talk about our descriptive nature, there is some evidence that we can get into these numbers. And again, the problem is we're talking about really small sample sizes, but they are being treated more seriously and have serious sentences.
Yeah, I think you mentioned the fentanyl offense. We went into the specific offenses in the guideline subcommittee because it felt like we needed to. The fentanyl offense, the commission made a higher initial category than a typical drug distribution case. So the fentanyl offense is the controlling conviction if there were 2 convictions in that kind of case. Isn't that right, David? Didn't we determine that?
Yes, correct.
So, yeah, that's it. Creates an interesting scenario there.
I'll just add, as not a member of the subcommittee in my role as chair, but I sort of sit and listen and will add some input. I think to Judge Avery's point, in my time on the commission, we generally have tried to look at it descriptive, like it's reflective of what judges are doing. Challenges do become when we have areas where there's data, even data that may indicate something, but it's not a lot. And so my sense, having previously been on the subcommittee and now sort of advising someone, is I then try to figure out almost the legislative intent behind that. And so one of the discussions, I think, to Rick's point, was it's not a requirement that there be jail. And that's true, these weren't the mandatories. So the question may be whether or not that affects, in my opinion, whether it affects the minimum, the bottom end of the range. But on the other hand, if you don't have an increase to the upper end of the range, then it's as though that offense has no impact at all. So you have the legislature that has passed something that is asking it to be consecutive, but it has no impact on guidelines, which seems at odds. And so I think, again, just so people will understand some of the discussion, and I don't want to speak for Rick, but I think your issue was an issue at the bottom end of the guidelines. I think primarily, I don't want to speak for you. And there was some discussion whether it should be reflected in both. In other words, both the top and the bottom should be stacked, or whether it should just be the top. I don't know if anybody else wants to weigh in. Yes.
I just have a question. So with you have an offense where you're committing a crime of violence in the presence of a child. I would, and maybe I'm wrong, I would think that most of the people that would mean the child was also a victim. And if the child was a victim, wouldn't that be an additional factor in the sentencing guidelines because of special vulnerability? And then you're also adding, stacking the sentencing guideline based on the fact that the offense is also that.
I don't think we analyzed it that way. This was used as an example, but I mean, actually, I don't think that we really.
Well, I think I could maybe speak to that a little bit. So an example of that kind of charge, and Rick, you can weigh in, but I think an example of that would be a domestic violence. So there is a crime of violence that's perpetuated on perhaps one parent or another, with the child being present. So the child may not themselves be a victim and not be scored that way unless they were.
That's an interesting question. We never thought it
Right.
could be, possibly.
Well, I mean, at least that's historically is what I've understood. I mean, it's certainly to be argued, but may not be a victim for purposes of victim scoring because they weren't the receiver of that abuse. However, there was a recognition that the children in the presence of that is a greater harm. So it may not be against the child as a victim. Now, it may be as well. It may be both are, and that sort of a different analysis. But I do think there are the times when it's not, and that speak to that.
No, I agree with that. I was just trying to figure out the majority of circumstances where you have crimes committed in the presence of children. I would think, and I don't know statistically what it is, that it would be an offense against a child.
Well, I mean, here the legislature passed this legislation that expressly acknowledges the harm to the child. So that is a consideration for sure. All right, but we don't have to do anything about it tonight. This is really kind of an exercise. We discussed it, how we should proceed tonight because we don't actually have to vote on anything. But I think it is good to do some review here, especially for the new people, so you understand what we're dealing with.
And maybe just add that if anyone has additional thoughts in the interim, please feel free to share them with myself or Judge Avery, so that we can consider those when we do eventually deliberate again on these particular.
And sometimes it's a puzzle, you know, you're really working it out, and the more minds who are working on the puzzle, the better outcome they have.
I definitely agree with that. I know, Mr. Harvey, you're one here, and Senator Sidnor. I don't know if anybody else on the subcommittee wants to weigh in. We'll give you the opportunity. Mr. Harvey, do you wish to weigh in?
Hey, you're on mute, Mr. Harvey.
No, I'm content to save the analysis for the subcommittee meeting.
All right, very well. Well, I guess we'll move on to the next one.
Okay, so the next matter is the review of crimes against animals and the scoring of the multiple victim stacking rule. And Catherine from staff did a lion's share of the work on preparing this memorandum, so we're going to ask Catherine to present this issue.
Sure. So I will now refer you to the memo labeled Crimes Against Animals and the Victim Stacking Rules. MSCCSP staff has received multiple questions involving animal cruelty cases, specifically whether an animal meets the criteria for a victim for the purposes of applying the multiple victim stacking rule in a criminal event with multiple counts of animal cruelty, each involving a different animal. Presently, Chapter 10.1 of the Maryland Sentencing Guidelines Manual provides instructions for the stacking rule and states, when there is a criminal event with multiple victims and not more than one serious category 1 or 2 offense, The person completing the sentencing guidelines worksheet should add the highest of the upper limits of the guidelines ranges for each victim to find the correct overall range for the criminal event. In a scenario in which there are multiple counts of animal cruelty, each involving a unique animal and stemming from the same criminal event, with not more than one seriousness category 1 or 2 offense, the question as to whether animals shall be treated as victims for the purposes of applying the stacking rule is an important one. The application of the rule could affect the calculation of the overall guidelines range considerably, depending on the number of unique animals involved. Maryland law contains slightly varying definitions of the term victim, depending on the context and the nature of the applicable statute. Most definitions found in Maryland law, however, specifically cite references to a person or individual and do not outwardly encompass animals. Relevant case law stemming from other states draws mixed conclusions regarding the inclusion of animals in statutory references to victims. Pages 2 through 4 of the memo highlight various case law. In some instances, the relevant appellate court has recognized animals as constituting separate crime victims for the purposes of merging, while in another case, a deadly weapon finding was overturned, stating the evidence is insufficient to support a deadly weapon finding under circumstances in which the sole recipient or being against whom a deadly weapon was used or exhibited was a non-human. MSCCSP staff analyzed Maryland sentencing guidelines data for sentences involving crimes against animals to see if the data provides any descriptive insight as to how cases involving crimes against animals are being scored in the guidelines and subsequently sentenced. On page 6 of the memo, Table 1 illustrates from 2017 through 2021, there were 108 sentencing events, including 241 convictions for crimes against animals. The most common crimes against animals were animal cruelty, followed by aggravated animal cruelty, dogfighting, and cockfighting. Approximately 31% of the 108 sentencing events involving crimes against animals involved multiple counts of crimes against animals. Sentencing events involving multiple counts of crimes against animals were substantially more likely to involve a sentence departure above the overall guidelines range relative to those involving single counts. To note, no sentencing event involving multiple counts of crimes against animals applied the stacking rule, as can be seen in Table 3 on page 7 of the memo. Of the 33 sentencing events involving multiple counts of crimes against animals, approximately 73% were imposed consecutive sentences for 2 or more of the counts of crimes against animals. Taken together, these findings suggest that judges at sentencing are more likely to account for each of the unique animals involved in separate counts of animal cruelty. Given these findings and given that the sentencing guidelines are intended to be primarily descriptive, the Commission may be justified in instructing practitioners that the stacking rule applies to animals as well as to humans. Applying the stacking rule in sentencing events involving a criminal event with multiple counts of crimes against animals would reflect judges' current practices and provide judges with the option of imposing consecutive sentences without departing from the guidelines. Applying the stacking rule would also maintain the lower guidelines limit as it is currently calculated. Given recent inquiries regarding the inclusion of animals as they relate to the stacking rule, the Commission may wish to take one of the following actions. 1, clarify the instructions for the stacking rule to explicitly include animals. 2, clarify the instructions for the stacking rule to explicitly exclude animals. Or 3, take no position on the issue and continue to recommend that judges make victim determinations based on the facts in each individual case. Potential revisions to the guidelines manual and COMAR based on actions 1 or 2 are provided on pages 7 through 9 of the memo. Lastly, given recent inquiries regarding the definition of a victim as it relates to an animal, beginning on page 9 of the memo, the staff has included additional action for the Commission to consider pertaining to the scoring of victim injury and special victim vulnerability. In addition to inquiries regarding the stacking rule, though infrequent, staff has also been asked whether an animal would qualify for victim injury and/or special victim vulnerability points on the offense score when a case involves an animal whose injury or death was directly linked to the conduct of the defendant. To note, crimes against animals are currently classified as property offenses for guidelines purposes and would therefore not require an offense score calculation. The question regarding victim injury points arose following several scenarios in which the defendant was also convicted of a co-occurring person offense, for example, wearing or carrying a concealed dangerous weapon, which would require an offense score calculation. At this point in time, staff is only asking the commission to consider whether an animal meets the criteria for a victim for the purposes of applying the multiple victim stacking rule, and will defer to input from the commission to guide whether the subcommittee should proceed with discussing the additional considerations addressed in the second half of the memo. And at this point in time, I will now turn it over to the commission for discussion.
You know, this is an issue that we discussed and we took no action on because we didn't have a quorum in our committee. We're interested in any viewpoints on the commission.
So I have a question. Say for instance, in a domestic violence situation, and there's an animal that's a support animal or a working dog, and harm is done during the occasion of domestic violence and to the support animal. Would that animal then be considered victim? Because maybe that support animal is used when that person goes to work and meets their financial needs, or to a child who needs it for the educational things. You know, I just want the supportive animals to be considered, I guess.
I mean, with regard to the stacking and sentencing considerations, I think that, I mean, I would tend to look at the unit of prosecution with regard to multiple animal involvement. I feel kind of quiet on this issue because I think that, you know, as a judge, my personal viewpoint about the content or the subject matter of the issue shouldn't be as prominent as, of course, maybe more of the structural issues. But so,
and I understand. I guess the question with regards to when animals were seen as a victim, I just didn't know if that escalated it because they had a different position versus a pet. So just wondering if the statute of they are starting to address.
Animals are not considered people in the law, under the law in Maryland. So, yeah, I think that it's an interesting question with regard to victimization. That I don't believe that Maryland law recognizes victimization of anyone other than humans. So, that to me, in my viewpoint, is the status quo on this issue.
Yes, thank you. We were, just talking about legislative intent with regard to the last issue, and as usual, the commission staff has prepared a fantastic memo on the points and authorities, giving us some guidance on this issue. But what sticks out to me is that here I think we have a clear expression of legislative intent, in that victim is defined a number of times in the law as being either a person or an individual. And then on the flip side of that, if you look at the definition of animal in the criminal law article 10-601B, it defines an animal. It says it means a living creature except a human being. So just in regard to this particular issue, whether we should treat animals as victims, I think we do have a very clear expression of legislative intent on this particular issue. Mr. Harvey,
Well, I think this topic is certainly worthy of further discussion in the subcommittee. But I will say in Calvert County and in Southern Maryland, in the past year, we've had at least 2 or 3 major dogfighting ring cases where there would be 20 or 30 victims. If we were to consider an animal to be a victim, you're going to have 20 or 30 victims. And I think it's going to create issues where the guidelines are going to end up going through the roof. So I would like to talk to my animal cruelty prosecutor and see what he thinks about all this. But I'm troubled by including an animal as a victim.
So in both of these 2 memos that we're just considering, we're really talking about issues of ambiguity in the statute. And we've got a General Assembly that starts to meet in a couple of weeks. Has this commission ever decided to send a memo to the General Assembly or to the appropriate committees of the General Assembly saying, we think there's an ambiguity here? It would be helpful if the General Assembly were to pass a bill which would clarify the situation. And you could even give us recommended language that could go one way or the other for the bill, rather, because it sounds to me like this organization is sort of trying to guess what the General Assembly wants in a case of ambiguity, and why not go to the source and ask them what they want?
I'm thinking, and to my knowledge, I think the answer is no. This commission has not done that on a prior occasion, but I don't think that precludes us.
Well, because also too, that I think affects advocacy, right? Because there's the statute itself, and these cases go up on appeal, and then there's a judicial review that would encompass some evaluation of legislative intent based on the wording of the statute, and using a matrix, a framework for that legislative intent analysis if it gets to that. I feel like if we as a commission were to ask for legislative intent, that we're asking the legislature to take action that is different from whatever the status quo is, and that in effect, no matter what the issue is, that in effect, I think creates an advocacy that what we're asking is that the legislature make change, because stating intent is going to be some change. That's my personal viewpoint.
Yeah, I guess my response. Oh, I'm sorry. Go ahead.
I was just saying, a few of us sitting here, so we now heard today. I mean, although I would agree with my colleague here that I believe the intent is clear. Person's been defined, animals been defined, and you're not a victim.
Yeah, maybe in this case there really isn't much ambiguity. I think in the first case there may be more than in the second memo. But I don't see why. Well, there are two ways this could go. Either with an ambiguity, this commission could adopt an interpretation, and then there would be a lawsuit that the interpretation was incorrect, which would then go up and ultimately be resolved by the courts. And then the General Assembly could decide, do they like the resolution that the courts made of it, or do we want to pass a statute which would change it? It just seems to me that if that's expensive for the litigants, and if there is an ambiguous situation, it might be helpful for the General Assembly to know that this committee is wrestling with the ambiguity, and it would be helpful to the committee if the General Assembly were to consider it.
If I just add in a bit, so there's actually a couple things. So I think to Judge Avery's point, and also I'll just add to that, asking for an opinion, then the question is who's giving this opinion of what the legislative intent is. So I don't know that would be able to be something that we could effectively use without, you would just look at what the purpose of the statute was, which is sort of what the courts would do, not asking the legislature to give us an extra, hey, what did you really mean by this, but interpreting it. The other issue I would just add on that, we deal with a level of ambiguity almost in all of those things that we do in the commission. So for example, when there's a new statute, a new crime that's created, no one is sort of telling the commission what the classification needs to be or how it does. That's sort of a process that this commission goes through and tries to ascertain what that may be. And so I would just say we kind of deal with that on a lot of issues. These are a little different, but at least my time here, I think we've had a number of those things. As far as I would just add, obviously there was a lot of discussion on the first issue that we raised tonight. The second issue I don't think has been discussed, so I didn't want to put it out there that this is a position, a subcommittee, and I'll let those members talk, there may be agreement and a joint recommendation to not include animals as victims. So I just want to make sure it was clear that wasn't actually discussed or there wasn't positions taken. So Mr. Zerma's position, I'm sure it was going to be part of the discussion in this. And Judge Avery brought up some matters. So that may not be an issue that would go differently. I mean, I don't know, but I just wanted to be clear that it actually hadn't been discussed. Anybody else? Yes.
Yeah, just briefly, I think the fact that these offenses are already categorized as property crimes suggests implicitly, right, that animals are not victims, or at least weren't intended to be victims. And if we were going to make them victims, it raises a whole lot of other questions about how do you score vulnerability of the victim? You know, you're going to use age and mental capacity of the pet to try to say it's a vulnerable victim. It just seems like we're opening a can of worms. And if the legals, I'm not a lawyer, but it sounds like there's clear legal definitions that wouldn't include animals. So it seems pretty straightforward.
I floated something before the discussion, when we closed the discussion, and that floated idea was that we can all agree that the gravity of an animal cruelty offense is increased by the number of animals that are killed or injured. But we have a provision to provide for upward departures in sentencings, and we could create an upward departure consideration for multiple animals in an animal cruelty case. And that would also address the guidelines, the recognition that there are some statistics suggesting where there's multiple offenses or multiple counts, they're above guideline sentences. So it seems to me that would make some practical common sense to address the question in this scenario.
And I just wanted to follow up and just say it wasn't an intent to open up a can of worms. It really was a question. No, I understand. So because simply when speaking with victims and they're asking about their support animals, I truly did not know if they were seen as an extension of themselves versus like a pet or in an animal fighting. So that was just simply a question, and no need to really take it to legislate. I'm sure it's going to get there soon enough eventually. With the amount of support animals that we are seeing. So it was just a question.
And I do think that there's a lot more recognition of the risks inherent in offenders who harm animals in terms of their, pro-social or anti-social consequences in the community. So, I mean, the judiciary is doing judicial education around the research on that as well. So, hot topic.
Yeah, and I think it's really helpful for the subcommittee to hear a lot of the feedback. I think that will certainly be added to the discussion. All right, well, it's the next matter, and that'll be discussed and then brought back for action in a future meeting.
Okay, there's one last item that we wanted to present to get feedback on, and that is agenda item 4C, and that is review of seriousness categories for subsequent drug offense convictions. And I refer you to the memorandum under that same page. The staff has received recently an inquiry from an assistant state's attorney questioning why the sentencing guidelines for subsequent drug offenses penalized pursuant to Criminal Law Article 5-608D are treated the same as first-time offenses penalized pursuant to Criminal Law Article 5-608A. Both of these are classified as seriousness category 3B offenses, even though a first offense has a maximum penalty of 20 years, while a fourth or subsequent offense pursuant to 5-608D has a maximum penalty of 40 years. The assistant state's attorney questioned why a subsequent offense, which has a greater statutory maximum penalty, would be treated the same as a first offense. Currently, the sentencing guidelines classify first offenses, which are enumerated in Criminal Law Article 5-608 and 5-609, the same as subsequent offenses, even though the subsequent offenses do carry a more severe punishment than first-time offenses, as I just noted. Narcotics and hallucinogenic offenses are seriousness category 3B offenses, while MDMA offenses are classified as seriousness category 3A offenses. The lack of distinction in the guidelines classification between subsequent drug offenses and first-time drug offenses is a relatively recent development. Prior to the enactment of the Justice Reinvestment Act, the guidelines recommendations for subsequent offenses were higher than those for first-time offenses because the mandatory minimum offenses associated with the subsequent violations under 5608B, 5608C, 5608D, 5609B, 5609C, and 5609D. So, for example, prior to the Justice Reinvestment Act, the guidelines recommendation for a subsequent offense under 5608D or 5609D would have been 40 years to 40 years, whereas the guidelines for a first offense would have been calculated using the drug offense matrix, which determines the guidelines recommendation based on the offense seriousness category and the offender score. So because the mandatory minimums existed prior to the Justice Reinvestment Act, the mandatory minimums essentially trumped the sentencing guidelines. So if there was a 40-year mandatory minimum, but the offense, let's say, carried the guidelines range was under normal conditions would have been calculated as 3 to 7 years, but there was a 40-year mandatory minimum, the guidelines would equal the mandatory minimum penalty, so they would have been higher because of this. Now, post JRA, the guidelines recommendations are the same for subsequent offenses as they are for first-time offenses, since they both have the same seriousness category, and there's no longer a mandatory minimum subsequent offense penalty that results in increased guidelines recommendations. Consequently, the staff was asking whether the seriousness categories and corresponding guidelines for offenses with different maximum penalties, for example, a 20-year maximum sentence for a first offense versus a 40-year maximum sentence for a fourth or subsequent offense, warrant review. Specifically, the staff recommends reclassification for the 5 subsequent offenses that are noted in the table on page 5 of the memorandum. The proposed revisions increase the seriousness category for each of the subsequent offenses to align with the comparable offenses when corresponding higher maximum penalty. As noted in the memorandum, an analysis of guideline sentencing practices indicates that circuit court judges tend to sentence drug offenders above the guidelines more frequently in cases involving subsequent offenses than in cases involving first-time offenses. To summarize, the staff is asking for consideration of reclassifications that are proposed on page 5 because these classifications will provide more consistency with comparable offenses based on their statutory maximum penalty and to differentiate the guidelines calculations for first and subsequent offenders. So that concludes my summary, and certainly looking forward to hearing input on this particular issue.
I have nothing significant to say other than I think it's a kind of common sense adjustment, but we may have some.
Point of information for the commission, a subsequent offense is defined as a second offense where there is an appropriate notice issued under the Maryland rules before the sentencing in the case. Is that correct? Not just that the person has a prior conviction. Okay. That's an important, I think, distinction.
Right, I think it's 214, 215.
No, I'm just saying for under the guidelines, that's what it is as well. That's what I was asking.
Yeah, you can see the number of convictions on page 6 in the memorandum. It's labeled Appendix 1 at the top. This is for this, as I noted, those 5 subsequent drug offenses. This is the data since the Justice Reinvestment Act went into effect, which was on October 1, 2017. So there are a few convictions for these subsequent offenders, but as currently constituted, the guidelines are the same for these as they would be for first time.
So again, just for reinforcement, this was just for the purposes of education and input today. There's been no discussion or decision by the subcommittee. So any comments?
Yeah, thank you. I just have one observation with regard to the recommendations that have been made. Certainly in the case of has a maximum penalty of 25 as opposed to 20. And, you know, that may merit some revision looking at, guidelines because we have this 5-year difference in terms of the maximum. But in kind of doing some, back-to-back calculations, what really stuck out to me is that if you make the fourth conviction a category 2 offense, you're really kind of blowing up the progression that the guidelines envision. It changes things really dramatically. As things are now, for a third conviction, you got to assume that the person is a major criminal record, and so they get an offender score of 5 on that. So as things stand now, sentencing cases, that person would have a range of guidelines of 1 to 6 years. Under vision, and it would be a 3C of that categorization, that the guidelines would be 2 to 8 years for a third offense. But if we were to adopt the proposed revision for a fourth offense, being a category 2, the guidelines would be 26 to 30 years. So it would jump from 2 to 8 to 26 to 30. It seems to me to be really out of proportion. I mean, I don't know. I think most people regard a third distribution as bad and a fourth distribution is bad, and I'm not sure it can be regarded as that, much worse or that kind of jump in the range of recommended sentence. And I think that the reason for this is that the comparison was made to the drug kingpin statute. And the drug kingpin statute is very different, in my mind, from a subsequent offense for distribution. Number one, we're dealing with, the person who's responsible for a criminal organization versus somebody who is dealing drugs. But again, under 5613, the drug kingpin statute, it's a 40-year offense, but it's also a mandatory minimum, 20 years without parole. And, it enacted the Justice Reinvestment Act, I mean, it's my understanding, is the intent of the legislature to do away with these mandatory minimum sentences with regard to subsequent convictions for the mere distribution. So I think, at least in my mind, by comparing apples and oranges, you have this huge jump in terms of what the effect of this change would be. You change the fourth conviction to a category 2. I don't know if it'd be more appropriate to come up with a 3D instead of a category 2 to try to come up with that. But having practiced in Baltimore County for 30 years, I think in going every year before the legislature and pointing out some problems with the prosecution of mandatory minimum offenses, that was the thing that would strike out. And it's like, here in this case, his second offense is that really so much worse than the third. Now we don't see too many fourth convictions. I haven't seen too many fourth convictions of distribution, but by bringing it in as category 2, I think it really creates an outline. So that was just an observation.
I think it's good feedback from the subcommittee for sure. And I think it's a point, I would just say, I think it's a good point in terms of analogizing perhaps to an offense that, although it maybe carries the same penalty, has a different impetus behind it from the kingdom. So I think that's good for the discussion of the subcommittee. For the staff wants to create a new category.
Yeah.
But yeah, I think it's great input.
Yes, anyone else wish to be heard on?
Well, the only thing I would add is that perhaps there was, at the time, we've been talking about legislative intent, but I wonder what the commission's intent was at the time after JRA with the guidelines as they stand now. So perhaps we have that history as well. We could look at, we meaning subcommittee that I'm not on, could look at that as well and, to see why it is as it exists now.
Yeah, that's
Yeah.
right. Feedback.
No, absolutely, yeah.
All right.
That's great. Thank you. Well, good luck to the subcommittee, have some good issues to tackle. And again, just like the others, this issue will come back for the full commission to vote. All right, with that, we get to go to Dr. Slay again for his
Okay.
executive director report.
All right, thank you. I have 5 items to report today. These aren't status reports, but please feel free to interrupt me and ask any questions, not asking for any actions on these purposes. First item to report on is about updates to the guidelines. At the commission's July meeting, we reviewed 3 separate topics that resulted in votes to approve corresponding sentencing guidelines updates. Just as a recap, first, the commission revised the guidelines worksheet protocol for non-original sentencing events to provide consistency by limiting the collection of sentencing guidelines from pre-judge panel reviews to those involving a crime of violence and to clarify the definition of reconsiderations. Second, the guidelines offense table was updated to reflect the classification of new offenses that were passed during the 2022 legislative session. And finally, revisions were adopted to clarify the definition of explosives as it pertains to the assignment of weapon presence points in Part C of the offense score. Now, each of these 3 updates were promulgated through the call review process after the commission's July meeting and were subsequently adopted effective November 14th, 2022. The commission also released an updated version of the Maryland Automated Guidelines System, MAGS version 11.0, and this was implemented to reflect the respective revisions and updates. The second item I wanted to report on was just to give information about sentencing guidelines training and feedback meetings. Since our last meeting in September, the staff completed 3 webinar trainings. On September 16th, the staff provided orientation and training for the judicial law clerks and other judicial staff. And on September 30th, we provided what we refer to as a MAGS 101 webinar for prosecutors and parole and probation agents to initiate the sentencing guidelines worksheets. And then on October 6th, the staff completed a similar sentencing guidelines orientation revolving around the utilization of the guidelines calculator tool, and that training was provided for public and private defense attorneys. And then I recently met with the judges in St. Mary's County on November 23rd. My goal is to meet with the judges in each of the 24 jurisdictions every 2 to 3 years. So this was part of my calendar, just getting ahead. I've been out to St. Mary's County in 2 years, so I was able to meet with them. The feedback meetings are really an excellent opportunity to review sentencing guidelines data, to discuss recent guidelines amendments, and to review the activities of the commission. And finally, to ask judges to share their input regarding sentencing guidelines. And as Judge DiLeonardo referred to earlier, it's also an excellent opportunity to get that type of feedback about the sentencing guidelines. And a couple of the topics that the commission has addressed have come up via that type of meeting when we meet with members of the judiciary. So they've been really helpful. The third item to report on is I just wanted to take an opportunity to review the Sentencing Commission's protocol for response to legislative proposals. And so if you could bear with me for a little bit on this, I just wanted to explain this. In 2019, this commission adopted a protocol for how to respond to legislative proposals, and specifically with those, if there's bills that have call for the commission to do something new or specific action by the Sentencing Commission. Just prior to 2019, there were multiple bills that were introduced with the potential to affect the Sentencing Commission. And given that the commission has typically set up our schedule that we do not meet during the legislative session. And that is done because we have, 4 members of our commission, and it's kind of a difficult time to be able to incorporate them. So we've always set up our calendar to kind of follow the same schedule, meeting in May, July, September, and December. So we adopted a policy to kind of guide how this body would respond to legislation that directly affects the sentencing guidelines or the operations of the Sentencing Commission. So I distributed a document that's titled Policy for the MSC Response to Legislative Proposals. And that just lays out the protocol that this commission agreed on. It's first that the staff should identify any legislative proposals that affect the sentencing guidelines or the commission's operations. And we shall promptly notify the chair of such proposals and try and identify bill hearing dates before the relevant legislative committees would know. Then that the chair and staff will schedule a conference call for this full commission with the purpose, it also could be a video call. Last time we actually did a video call, with the purpose of soliciting feedback to request a vote, whether this commission would specifically support, oppose, or take no action on proposed legislation. And then the commission would provide prompt notice of the scheduled date and time for this particular meeting and offer public access by publishing, whether it's a call-in number or a link to the video on our website. And then the commission agreed that we would adopt the majority position. Those commission members who participated in that meeting and voted, provided that a quorum was met. And then the chair and the sentencing guidelines subcommittee would convene in a timely manner after that to consider the bill and after receiving feedback from the commission, decide whether it was necessary to present the position of the commission to legislative committees, legislative leadership, and or the governor, really to make a determination about whether we are presenting formal testimony, whether presenting written testimony or in person, et cetera. And then the staff would, in conjunction with the chair and the subcommittee, prepare formal testimony, which we would then also share with the full commission. So I just wanted to kind of review that protocol in anticipation, and should any bill arise with the legislative session that's starting here in a couple of weeks, that this is the protocol that we had in place. So it is possible that we may reach out to you to try and schedule on the fly a meeting of the Sentencing Commission. And we would do it virtually in that scenario. So that's something that could happen potentially, probably not in January, but probably early February. Probably February would probably be the main time that would likely happen.
Just jump in.
Sure.
So this policy, I was actually on the commission back then when this first happened, and the legislation there was legislation that affects sort of the function here. I just want to make sure I'm clear. And there wasn't really a procedure, and I think this was a procedure that being developed at the time. So, and Dr. Slade can certainly correct me if I'm wrong, but there's going to be legislation every single time that's going to affect guidelines. A new crime is created, a crime is reduced in terms of the maximum sentence. It was pointed out lack of mandatories. I've not seen that that's the role of the commission, even though it affects the guidelines. It's not that we're advocating everything else. I think it was focused on legislation that directly impacts how the commission operates. So for example, I think there's been legislative issues that have asked the commission to take on projects or to undertake data collection and that kind of thing. And so it's not a great position if the commission doesn't weigh in on what effect that may have. And it doesn't, whether it's pro, con, or yeah, that's great, but we need the resources or the money to do it. So I just wanted to kind of be clear. It's not meant to be an advocacy for a particular way that criminal offenses are handled or the way the sentences are created. It's really, I think this legislative function has been geared at, for example, what information would have to be disclosed about judges' sentences, for example. Well, that would obviously very much change the work of the commission. So I just thought it was good for everyone to understand. It's not as though we're just picking out something that we don't think that's a good idea to do that with that crime. That's not sort of what you would get called in for.
Right. I appreciate, thank you so much for making that distinction, because that obviously every year there's going to be multiple bills introduced. And I will say the commission provides data about those bills for every single bill that's introduced that would create a new offense or, decrease or increase in penalty for a particular offense, the commission, like our public safety and the judiciary as well, we are providing data about that. And I think that's one of the great things that we do. We have really good data in a lot of these instances to be able to provide that type of information. So we will fill out a fiscal information statement that provides that information to help guide the Department of Legislative Services in creating the fiscal policy notes that they create for each bill. But I'm glad you made that distinction though, really talking about like bills, not increasing penalties or something like that, but it's like something that's calling for the commission to take some new action or a proposal that is really altering the way we operate.
Yeah, I mean, there's been some, for example, of not considering certain aspects in creating sentencing guidelines, and sometimes it may not be taking a position, but feeling we need to go in and educate how those factors are, how we come to that, the data that leads to those decisions being made, which may not be readily apparent. So I would also just add to that, if you know of legislation that gets introduced, or you have, because we all have different, again, judicial partners, and you may say, oh, I hear there's something with the commission. It is helpful if you can give a heads up or let us know about that, so it's not so rushed in getting everyone together. And sometimes it will be helpful. I know the staff probably appreciates that.
Definitely.
All right.
With that said, has the commission, or specifically Chair and Executive Director, have you all ever done a briefing for the Judiciary Committee or Judicial Proceedings Committee in the General Assembly?
We have, I have done that for both the Senate Judicial Proceedings Committee and the House Judiciary Committee. I'm trying to think of one of them.
Yeah, I'm thinking, given the fact that we're having 30 whatever members come in, I don't know how many are going to be on, which committee, but I think it could be time perhaps to do another briefing. I'll talk to the chair. I mean, I'm sure he's already got his schedule outlined, but in case he doesn't, I'll just mention it to him. If that's something.
Down in the session, there's always kind of opportunities for that type of thing. So we're certainly receptive to that. Happy to do so.
Okay. And I know, and they've done a great job with that, even with other groups. Sometimes, whether you have a different group, that it's helpful, and David staff all do a wonderful job with that, because sometimes it really is. Normally, we didn't get the public comment this time, but many times there's comments where people don't really understand what the role of the Sentencing Commission is or how this gets done, and perhaps sometimes thinks that we just change what the rule is. And so it is helpful, I think, for people to understand that sometimes.
Okay, great. Just a few more items left to report. I just want to provide an update on the annual report. The Sentencing Commission's 2022 annual report is due on January 31st of 2023. The staff has begun preparations for that. Mostly this is kind of like our data cleaning period right now, where we're going up and doing some data cleaning, getting that data ready for the analyses that are included in the report. But our plan is to distribute a draft for commissioners to review on or about January 14th, which gives us a couple of weeks to incorporate your feedback and address any questions or concerns you may have. So I'll send an email out with the draft of the annual report, and we're happy to incorporate your feedback at that time. So that'll probably be the next thing that you can expect to receive from me. Okay, the last item that I wanted to discuss was the data dashboard for crimes of violence. This is something I mentioned in the presentation during the public comments hearing. So I just wanted to give a little bit more information about that. As I mentioned, there was legislation passed last year during the 2022 session. Among many other provisions included in that particular legislation, which was Senate Bill 763, which, for example, there was the creation of a task force to study transparency standards for states' attorneys. But our role was that the commission was asked to add to our annual report a new section that provides additional sentencing details about crimes of violence. Specifically, the report will provide information disaggregated by judicial circuit to include the following: the number and percentage of sentencing events that involve a crime of violence, the number and percentage of sentencing events that involve a crime of violence that resulted in a departure from the guidelines, the number and percentage of departure reasons cited for sentencing events that resulted in a departure from the guidelines. And then finally, the average total sentence, the average non-suspended sentence, and the average percentage of the total sentence that was suspended for sentencing events involving the crime of violence. Senate Bill 763 also requires the Commission, as I mentioned previously, to create a data dashboard to be displayed on our website to report this information, which we will be adding to our annual report moving forward, involving sentences for crimes of violence. So the Commission's annual report, as I just mentioned, is due on January 31st, and that is the first annual report that requires this additional information. So we are working to create the data dashboard, and the plan is to publish that dashboard on the Sentencing Commission website to correspond with the January 31st annual report due date. In addition to the data dashboard, the Sentencing Commission is also working to create a data extraction tool on the Sentencing Commission website that will assist in making the sentencing guidelines data even more accessible. As you know, the sentencing guidelines data are publicly available, and the staff routinely receives and responds to requests for data from a variety of individuals, including legislators, other judges, prosecutors, defense attorneys, victims, defendants, academics, and also the media. Currently, requests that are submitted to the Commission, they use an online request form from our website. They fill that out, and then once we receive that request, our research director, Stacy Najeka, follows up with the requester and confirms that the request was received and obtains any needed information to clarify the request. And once the requested data file has been generated, it will be emailed to the requester along with a data code book and a brief memo which describes the files that were provided. Our goal is to create a data extraction tool to streamline this process and allow requesters to download the sentencing guidelines data directly from the Commission website. The tool will permit requesters to filter the data by select criteria, including sentence date, jurisdiction, and offense. Once the criteria have been specified, the tool will generate an Excel file that can be downloaded directly by the requester. The data extraction tool is expected to make the publicly available sentencing guidelines data even more accessible than is currently the case, while also reducing the amount of time spent by staff responding to individual data requests. So just to make the distinction, the data dashboard would be kind of select data points that I was going to say we've chosen, but the legislature has chosen for us by virtue of this legislation, that we will be displaying the data. And you would be able to filter it out by individual judicial circuit, et cetera. There will be some option to plug and play and pick. Whereas the data extraction tool would be your ability to go in and say, I want to get all the data from the last 5 years for Baltimore City and Baltimore County, you know, and that type of thing. So it's to get the full data set, but also to provide some ability to the people that are requesting the data to kind of pick and choose what particular subset of the data they would like to receive. And we're doing this, as I think I tried to say, I mean, these requests are increasing. And so it's not that they're so much time consuming, but we just figured if there's a way that we can allow people to download the data themselves, I think it's a win-win for both sides, both from the staff standpoint and for people that are looking to easily access the data. That's it. Actually, sorry, I had one last item which I just added. I apologize. It's an announcement. And I'm really happy to report that we have completed our application review process, and for the new research analyst position that was created this past session. And we have offered that position to, and it was accepted by what we think is a really strong qualified candidate. And she is scheduled to start for us at the beginning of the new year on January 4th. And so I look forward to introducing her to all of you at our next Sentencing Commission meeting. But we're really excited to have an additional member of our staff joining us.
I just want to give anyone an opportunity, any questions about any of the status reports? Dr. Sule? I just had one question. I was curious on the extraction tool. So is that in any way restricted, like registered user or MAGS users, or it's just going to be a public, fully public?
Our plan is to make it fully public. Right now, we don't have any restrictions on who we would give data to if they requested it, so.
Okay, no, that's why I was wondering. I didn't know. if you had
No. We're
Somehow
not gonna
registered
require,
bags.
no login, we're not gonna require. login.
Okay, all right. And then I guess the other is that data is just broken down again, similar to the dashboard, just by certain.
Correct, yeah, so it won't include individual identifiers. It would be an aggregate data set. It'll have some additional variables in there. Actually, you would have the ability to look at it by individual jurisdiction if you choose to do so, but it won't contain the individual vendors identifying information.
So can I just ask if you considered possibly putting like an introduction to the data
Yes.
that the user would have to say, I've read and I understand where the data, basically what it is and where it's coming from before they're allowed access to it. So I do think that there is some filtering in the phone call, just so that people, if someone is inclined to use the data for mischief, that at least we've said, okay, you had to at least say that you understand what this data is and where it's coming from.
Yeah, I think that's so. We talked about this, and Stacy can correct me if I'm wrong. We are developing language to kind of explain what the purpose of the data is and any also limitations to the data. I'm not sure that we intend to have a checkbox that said how they're using it, because we're not allowed to limit
how
the use.
they're using it, but rather that they understand where it's coming from.
Yeah, we are it's still in development, but we have asked like the programmer to include a statement where the individual is basically acknowledging by downloading the data, like the source of the data, and saying there may be errors in the data because they're collected by humans, but then also the individual will acknowledge by downloading the data that they won't identify any individual in the data set. Now, there's nothing in our data. There aren't names for personal identifiers, but they could potentially link our data to another source and then identify someone. And there's nothing to prevent them from doing that now, but we do have a disclaimer in there to say they won't identify individuals.
Right. And believe it or not, that's not my primary concern, because that is that's a risk that's coming with this. But more that users aren't confusing the sentencing commission data with judiciary data or DPSCS data. It's so that they understand what the nature of this.
All right.
If I may add, will there be a substantial, I would say, data dictionary?
There is already.
With that, because with our, I think we've had 7 releases now of some various dashboards, and the data dictionary has been invaluable in really making sure that individuals understand what they are reading, the data point, how it's either legally defined or defined for the purposes of that release.
Yeah, we do have a data dictionary, and it's actually on our website. So people know before they request the data what is there and what isn't.
Thank you, Secretary. That's a good point. That we have been in communication from from your staff about the dashboard, because the public safety does have a great dashboard up right now that has really great information available. And I know Angelina, I think, has been the primary person for creating that information and contact, and she was very helpful for us, kind of because it's like treading it in new order with creating these data dashboards. So I just wanted to express my appreciation through you for her being able to provide that guidance to us. It's been very helpful.
The dashboard has an interface that allows for users to download data, or is it just
It's so in short, they can go into the data. The way we designed it is in 90 seconds or less, be able to drill down into what you're looking for, either by jurisdiction, by county, by charge, and be able to look down into the information. It does not it has limited connectivity to a full data dictionary download where you can just, roll out an Excel spreadsheet or whatever it is. It doesn't connect in that manner. Some future versions may, but we're trying to really also allow an individual to drill down into what our most prominent questions are, what they're looking for, and we're continually adjusting both the dictionary and how that dashboard moves. But it doesn't go into this data dump of, if you will, that then is left to interpretation.
All right. Well, so as not to tax everyone too much during the holidays, we only have one action item tonight. Well, two, I guess, the minutes, and then when we're going to meet again. So you'll see in the agenda, there is Tuesday, May 9th, 2023, Tuesday, July 11th, 2023, Tuesday, September 12th, 2023, Tuesday, December 5th, 2023, which would be public comment, as well as the meeting. So I would just need a motion to approve those new dates. Second. Any discussion about the dates? No? All those in favor, say aye.
Aye.
Anyone opposed? No? Okay, is there any old business? Seeing none, any new business, announcements? I mean, you've got your announcement already. Anything
Right.
else? None? All right, well, I will remember this, Ms. Williams is joining us tonight, but will not be joining us again. Moving on to, I'm sure, greener pastures, which is sad. I know we were all looking forward to being able to get you to be such a great contribution, but thank you for coming tonight.
Thank you, God.
And make sure whoever is coming now, on behalf of the Attorney General's office, lives up to the mark that you made tonight. All right.
Thank you. Thank you.
All right, anything else? All right, with that, make a motion to adjourn. Second? All right.
All right. So, Jake, great. I'll see you.